Ito ang balita ngayon. Viral at pinag-uusapan ngayon sa mundo ng social media. Ang di umano'y balita. Ito ang breaking news ngayon. Di umano'y usap-usapang impeachment complaint na kinakasa ng mambabatas sa Kongreso kay Vice President Sara Duterte na pinamumunuan umano ni Speaker Romualdez. Tila pinatitigil na at may matinding mensahe sa mga House leaders ng Kongreso ang Pangulong Bongbong Marcos. Totoo kaya ito mga kababayan? Ating alamin. Pero bago ang lahat, kung bago ka pa lamang sa aming channel, please huwag kalimutang mag-like, subscribe at i-click ang notification bell para mas maging updated ka palalo sa lahat pa ng bagong video na i-upload namin. At eto na nga mga kababayan, matapos ang tila panggigipit ng Marcos administration kay Vice President Sara Duterte at lumabas sa publiko ang usap-usapang impeachment complaint na ihahain sa kanya ng Kongreso. Ito ang nakakagulat, bagamat hindi pa man kumpirmado. Tila nabahag ang buntot at di umano'y natakot ang Pangulong Bongbong Marcos.
Ito na nga, pag-usapan na po natin, hanggang mga taga Mindanao nagwarla na, nagalit na, at magdideklara ng digmaan sa pamamagitan ng pakikipaglaban sa Supreme Court. Nagpasa ho sila, yung mga abogado sa Mindanao ay nagpasa ho ng reklamo patungkol dito sa impeachment proceeding na nangyayari dahil nga po sa sabi nila ay sabi po namin ay kasama po pala ako dyan. Sabi po namin ay itong impeachment na ito ay talagang illegal dahil hindi ho sinunod ang tamang proseso. Maling proseso, masyadong minadali at pinaspaso para sa halagang 150 million bawat isang congressman. Hindi, walang ganon. Basta ho, pinaspas po, sobra-sobra itong impeachment complaint na ito at tila ho maraming violation na ho ang ginawa nila. Kaya ito, inireklamo na ho ng mga Mindanaoan lawyers, mga taga Mindanao, mga abogado na sa Mindanao, ito inireklamo na. Sa pangunguna ho ni Atty. Torion, ang pinakamatikas na abogadong nakilala ko sa sobrang galing nito ay talaga nga namang gusto ko nang mag-law. Pero ito nga ho, at dahil ho dyan, marami hong nag-react. Nag-react po itong mga kongresista natin na sinasabing hindi naman totoo yan, ganyan. Ito, paliwanag na ho ni Atty. Torion kung ano ho ba yung ginawa ng mga taga Mindanaoan lawyers. So ito, pasok.
So let's bring in one of those challenging for ouster. We've got with us tonight lawyer Israelito Torion. Welcome back to the big story. Atty. Torion, good to see you again.
Bakit ngumingiti ka? Ikaw babaeng nakapula. Anong ibig mo sabihin yung pagngiti mong yan? Hindi ko kursunada yung pagngiti mong yan, ha? Biro lang. Maganda pa naman yung asawa ni Atty. Torion. Hanggang ngumiti ng ganyan. Baka kurut-kurutin siya Atty. Torion ng asawa niya.
Hello. Good evening, ladies. Good evening to the viewers of this popular TV station. Thank you for inviting me again.
Good evening. Iba naman topic natin tonight. Okay, first of all, why don't you give us the backstory here? How did this group, we're talking about the impeachment petition that you filed yesterday, or the other day, sorry, Feb 18. Tell us the story. How did this group of 29 Mindanaoan lawyers come to be and who initiated it? 29
Mindanaoan lawyers ang nagpetition sa Supreme Court. Naku po, malupit itong mga lawyers na to. Tapos may iba pang kasama. Mas malupit pa yung mga kasama. Pakinggan natin si Atty. Torion.
Well, actually, when I watched the news about the filing of the impeachment complaint in the Senate by the House of Representatives, I am a law dean and a law teacher. So I noticed that the
take note, ladies, this is a law dean. Hindi lang ho ito yung pipitsugil lawyer na katulad ni Libayan. Ito po ay dean. Dean po ito ng isang universidad. At itong universidad na ito, may 100% na passing sa bar exam ng pag-aabogasya. So ibig sabihin, talagang malupit ho itong dean na ito. Di ba? Tuloy.
impeachment complaint was really prepared in a rush, in a blitzkrieg fashion. All in the last day of the session, congressional session, and last minute, literally. And I noticed that there was no proper verification that was conducted, because I know that impeachment process is supposedly a solemn process, and it is not merely a numbers game, and it is supposedly bound by stringent procedural requirements. But all these were not followed by the House of Representatives. Instead, they rushed the complaint, and that is why I decided, I discussed it with my associates, and I have good constitutionalist in my small law firm, and we crafted an impeachment complaint, and I showed it to my colleagues, such as Attorney Martin Delgra, who is the lawyer of President Rodrigo Duterte, and I also showed it to Attorney James Reserva via Messenger, who is a known practitioner also in in Butuan, and other friend lawyers such as Attorney Luna, and the Vice Mayor also of Davao City, and other councilors.
Grabe, ang lulupit ng mga kasama dito. Talagang yung mga kinonsulta niya na para maipasa itong petition na ito ay talagang mga malulupit.
And I also showed it to Banatbay, Banatbay, Coach Oli, and Boss Dada.
Malupit pala talaga itong petition na to. Mantakin mo mga sobrang mga matitigas na abogado, mga congressman, vice mayor, mga malulupit na mayor, tapos biglang pinasukan mo na ni Banatbay. At saka ni Coach Oli, tsaka ni Boss Dada. Mas lalo palang malupit talaga ito. O, pakinggan natin.
And they are interested in joining me. So I included them as petitioners. There were some suggestions also given by the other petitioners, such as Attorney Martin Delgra. So we finalized it, and we have that petition that we filed in order to question the impeachment complaint filed against Vice President Sara Duterte.
So in short, you initiated this.
Yes. Therefore,
I initiated it. I provided the impetus and the idea, and presented it to my lawyer colleagues. More heads are better than one.
Yeah. Ako yung isa sa mga colleagues niya. I'm so honored, Mr. Attorney Torion, to be included in this petition. Thank you very much for your inclusion.
And there were suggestions to and fro. So it was actually revised 12 times before it was finalized. Yes.
Do I take it to mean that are you a counsel of Vice President Sara Duterte, or do you want to be?
No. I filed it in my own personal capacity, and as a matter of fact, she did not know anything about it until the filing of the petition before the Supreme Court.
Because she herself obviously filed her own petition for TRO,
I did
right?
not even know that. I did not even know that. I
Tama yan.
heard about that when I browsed my Facebook, I think yesterday.
So
and
you did not
I
coordinate.
did not have any idea that she filed before us.
Okay, so there was no coordination, there was no working together. Okay.
Definitely.
Okay, I wanted to focus, Attorney Lito, on one you were saying in your complaint to the Supreme Court that the 3 prior impeachment complaints were not considered. We have spoken to a bunch of the lawmakers in the lower house. Ang sinasabi nila, itong 4th complaint ay binasa nila doon sa previous 3 complaints that according to you, they malicious in action. Inupuan nila ng matagal, maliciously. They argue that they actually made this 4th complaint to summarize and make more concise the points in the first 3 complaints, because the first complaint was sobrang dami daw articles, 20 plus articles, etc. So what would you have to say about that?
So, sinasabi daw ng mga congressman, tagalugin ko lang ha, itong complaint na 1, 2, 3, yung impeachment na pinagsama-sama ng daw nila doon sa pang-4th. Napakasinungaling talaga nito mga congressman natin.
Kung yun yung
that's a lie.
explanation nila.
Baluni.
Baluni. Alam sabihin ng baluni. Mas magandang ano 'yun, mas less harsh sa pagiging tanga. Ganun. Kalokohan o stupid, parang ganun. Oh, 'di ba? Parang that's baloney, hindi totoo 'yan. Huwag kayo nagpapaniwala sa mga kongresista natin. Hindi totoo na pinagsama-sama 'yan. Oh, 'yan ang. Bakit? Bakit kayo?
That's baloney. Because you could never see that in the fourth impeachment complaint.
Yo.
Those are afterthought, no? And besides, the Constitution is very specific. If you will read Article 11, Section 3, no, Paragraph 2 thereof states that when an impeachment complaints are filed in 3 ways. One, via a member of the House when he files himself an impeachment complaint. Second, by any ordinary citizen, and there is going to be a congressman that is going to endorse that complaint. And then the third way is when 1/3 of them would agree to file a complaint. But in this, under Article 11, Section 3, Paragraph 2, in relation with Rule 2, Section 3 of the House Rules on Impeachment, there is a mandatory requirement that upon the filing of an impeachment complaint, if you read the Constitution, there is a mandatory action on the part of the House of Representatives to subject it to the order of business within 10 session days. And for the Speaker, if you will read Rule 2, Section 3 of their own rules, mandate that the Speaker should include it in the order of business within 10 session days and refer it to the Committee on Justice within 3 session days. And the word use is immediately.
Yon, malinaw ho yun. So hindi ho pwedeng itenga ang isang reklamo o ang isang impeachment. Hindi mo pwedeng itenga yon at sabihin mo, sandali, i-consolidate natin yan, pagsasama-samahin natin yan. Hindi pwedeng gayon. Kailangan, pag may nag-submit na sa'yo, immediately, nasa rules nila, immediately, kailangan reviewin yan at tignan at dalhin sa Committee on Defense or Justice ba yun? Tama. Tama ba yun? Kaya.
But they never acted on it. They keep citing Gutierrez versus House of Representatives to counter my argument on the concept of initiation, but they forgot that Gutierrez versus House of Representatives, there were 2 complaints filed, but in the first 2 modes. Okay, it was not filed by 1/3 vote, and even in those cases, if you will read the case in its entirety, no. First, now Senator Risa Hontiveros Baracuel filed it prior to the opening of Congress. But when Congress opened in that case of Gutierrez, no, the Speaker of the House immediately had it the next day referred to the order of business within 10 days. And then thereafter, it was referred to the, to the Committee on Justice within 3 session days.
Committee on Justice pala. Kasi doon sa isa kong video, Committee of Defense ako ng Defense. Committee on Justice. Sorry naman. I stand corrected. Committee on Justice.
The only question there was, can you legally refer 2 complaints at the same time? And according to the Supreme Court, yes, because initiation means filing and referral to the Committee on Justice. But in this case, they maliciously never acted on the 3 complaints.
So nagsasite daw yung mga congressman ng isang parang nangyari noon na sinasabi nilang, hindi, bakit ito na hindi kaagad, hindi na-apply yung 1-year ban. Ang sinasabi nito, hindi man na-apply yung 1-year ban, pero ni-refer kaagad doon sa, umandar kaagad. Ibig sabihin, tinanggap, pinasa sa speaker, ni-refer sa Committee on Justice, at doon dininig. Diba? So, importante ho yun. Ang problema kasi, nung tinanggap yung unang 3, tiningga nila, sandali. Hindi pwede yan. Antayin natin yung pang-4. Yun ang sinasabi nating malicious na ginawa ng Congress. Hindi dapat ganun.
which is therefore a grave abuse of discretion amounting to lack or excess of jurisdiction, which now call to operation Article 8, Section 1, which is the expanded concept of certiorari, which gives authority on the part of the court to determine whether or not there is that abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Therefore, the Supreme Court now has the power and requisite authority to exercise this certiorari jurisdiction and declare the complaint filed before the Senate as void.
Yun. Halinaw.
Let me pick on, so you raised two issues there, right? So verification, 1-year bar. Let me pick on the
Yes.
point about verification because you're right, the House rules say that complaints should be immediately transmitted to the office of the Speaker as soon as they are verified. But the House Prosecution Panel members, with whom we've spoken to a number of, they said that nowhere does it say in the House rules that there is a specific number of days that verified complaints can stay in the SecGen's office. Hindi naman daw specified yung number of days.
Well, if you base it on jurisprudence, the requirement of immediacy is there. And that is, what you call this, clear in Gutierrez versus House of Representatives and even in Francisco versus House of Representatives. Now, just because it is not there does not mean that you will maliciously freeze it, because the mandate of the Constitution is such that they should act on it, determine whether or not it is sufficient in form as well as whether or not it is sufficient in substance by the Committee of Justice, because impeachment is a solemn process. It is meant to safeguard, not subvert our democracy. Because if you will just make this as a numbers game, then the fear of the Supreme Court in the two cases that I mentioned would be really present, such that it can be used as a political expediency. It would be used to consolidate or gain power, political power, by removing a high official who has been elected by 32 million, more than 32 million votes. So the processes, the verification requirement is a solemn process that must be complied with.
Yo.
And verification has three modalities. Number one, that you must have personal knowledge of the recitations of the complaint, or your knowledge must be based on authentic records, or both. And as a matter of fact, if you will base it now on the 2019 Rules of Procedure, Rules of Civil Procedure, these requirements are very strict, such that if such is very strict in ordinary complaints, it should be stricter in impeachment complaints, because you are now seeking to remove high public officials voted by 32, more than 32 million votes.
Feeling ko yung mga nag-i-interview sa kanya, pag binabanggit ni Torion yung 32 million votes, parang na ano sila, no? Parang na, huwag mo nang banggitin niya. Ayaw namin niya kay Sara.
I think that one of the issues I'm seeing here, Attorney Torion, and let me make it clear that I'm a total layperson here. Hindi po ako abogado, hindi ako nag-aral ng law. But when you say malicious in
Gusto mo mag-aral kay Atty. Torion? Ba't mo kailangan sabihin yun? Dahil, biro lang ha. Nangiintriga ka ba, Nat?
right? How do we prove malice on the part of lawmakers in the lower house? How do we say na yes, malisyoso sila kasi ang tagal bago nila, i-refer
Inakyat.
sa Justice Committee, which didn't even happen, or ang tagal
Why
bago nila...
malicious?
Oo.
Why malicious? Because it is supposedly, the action is supposedly immediate, yet they did not, they slept on it. And they know because of
Tinulugan nila, tinulugan nila yung unang tatlong complaint. Diba? Kaya malicious eh. Bakit inantay yung pang-fourth?
Francisco versus Court of Appeals, when will Section 3, Paragraph 5, Article 11 of the 1987 Constitution operate, which is the one-year bar rule? In Francisco, which is 2003 case versus House of Representatives, it was ruled that it will start the one-year bar rule, meaning you could not anymore file a case legally against and constitutionally against a high official of the government if this operates. And when shall it be counted? Upon the filing and
On.
referral to the Committee on Justice.
Yun.
That is why they did not act on it so that the one-year bar rule will not operate. And that is
Yan.
why I
There
term
is-
it as malicious.
Ayun! So, kaya sinasabing malicious kasi sinadya nila. Sinadya nilang hindi mag-act doon sa impeachment 1, 2, 3. Hindi nga nila sinagmit doon sa Committee on Justice. So, ibig sabihin, doon pa lang malalaman mo na there is a malicious motive o intent para ho na dumiretso na doon sa fourth impeachment complaint. Yun yung ating ipinaglalaban dito, di ba? O, galing talaga ni Atty. Torion.
Because supposedly, they should have acted on it because that is a constitutional injunction. That is a command by the Constitution.
Yan.
And their own rules, Rule 2, Section 3, likewise mandates it, and therefore it is a command. And their refusal to follow the command is actually motivated by their
Ayaw.
desire for the one-year bar rule not to operate. And
Yan.
therefore, that is a grave abuse of discretion amounting to lack or excess of jurisdiction which can now operate to make the Supreme Court have the authority to strike the complaint as void.
Yun. Ang galing. Palakpakan. Natameme yung mga host. Hindi naman ganun ba? Hindi, totoo naman di ba? Kaya nga sinasabi natin, may problema. Kaya nga ho nagagalit ho at nagrereklamo ho yung mga Mindanaoan lawyers at kasama ang banateros dahil nga po sa mali ho yung ginawa. Hindi ho nila sinunod ang kautusan ng ating konstitusyon. Hindi ho nila sinunod yung kahit yung kanilang rules. Ika nga. Sila mismo hindi sumunod sa sarili nilang rules. Ilang beses na nila ginawa yan, di ba? Ilang beses na pinoint out ni Marcoleta yung ganyang klaseng galawan nitong mga congressman natin. Ganyan ho sila. Oh, sus, Ginoo, sinabi ko sa inyo. Tuloy natin.
No, Attorney, I just want to know, other than this, while waiting for the Supreme Court's ruling, kung magagrant po itong petition na to, meron po ba kayong mga ibang ikinakasa to prevent the trial from happening?
Well, that's the only way by which we can, only the Supreme Court can stop it, and that was clear in Francisco, in Gutierrez versus House of Representatives, and this expanded concept of certiorari jurisdiction is now enshrined in the 1987 Constitution. Now, there is one professor of law I saw on Facebook, he said that if this is so, then why raise it with the Senate? Well, my polite reply is the Senate's power is only those clearly mandated under the 1987 Constitution, because impeachment, while it may be lodged in the legislature, is not its usual duty. Its usual duty is to pass laws. So therefore, only those power expressly granted by the Supreme Court, which is to go to trial if there is a verified complaint, that is the limited power of the Senate. It cannot declare the complaint as void.
Gets nyo? Kasi marami nagsasabi, bakit hindi na lang yung sa Senado inireklamo yan at sabihin? Dahil pinapaliwanag po ni Atty. Torion, hindi po jurisdiction ng Senado na magsabing void yan. Ayan po ay jurisdiction ng Supreme Court. Dahil nga po, ang Senate, as part of the impeachment process sa Pilipinas, they would act as a judge once yung complaint ay naipasa sa kanila. Parang ganito yan, mga kababayan, di ba? Sabi ko nga sa inyo, parang kaso yan eh. Parang sa piskal, yun yung Congress, yung House. Pag nakita nila na may probable cause, isasagbit ngayon ng piskal sa korte, di ba? Pwede ka ngayon magreklamo sa Supreme Court para kadari meron ka ng basis for para ipalipat o kung ano man, kasi marami yan pwede kang tumakbo kagad di sa Supreme Court. Ayan ang sinasabi ni Atty. Torion. Although, siyempre sa regular court, yung sinasabi nga ni Atty. Torion, ang talagang trabaho nila ay yan. Yun yung sa regular court. Pero pagdating po sa Senate, hindi ho yan talaga ang trabaho nila. Nagiging trabaho nila yan once tinanggap na nila yung impeachment na sinend ng Kamara. So, ang magdi-decide na kung yan po ba ay valid, kung may question ka sa Supreme Court po. Yun po ang sinabi ni Atty. Torion.
Because that is a judicial function which only the Supreme Court can exercise.
Yun.
On
Linaw.
the issue of the one-year prohibition rule, I think you answered your own question there. Correct? Again, House rules state that a complaint is considered commenced only after it is referred to the Committee on Justice, which the
Yun.
first 3 complaints were not. So technically,
Yes.
hindi sila na-file.
Shoot.
The ban only applies when the impeachment process has been formally initiated, which only happened on the 4th complaint. So
Yun.
that's a
Yes.
technicality there.
Yes.
It's not a technicality, it's a constitutional defect because the mandate to act on impeachment complaints is mandatory. The immediacy thereof has to be followed. And the fact that they did not follow in order for the one-year bar rule not to apply makes their complaint, the 4th complaint, as void because it is constitutionally defective and it did not follow the mandate of the Constitution that the first 3 complaints, no, even if they referred the 3 complaints at one time in accordance with Gutierrez versus House of Representatives, that could have been, argued as valid because in Gutierrez versus House of Representatives, there were 2 complaints that were simultaneously referred to the Committee on Justice, but the immediacy requirement was complied with. No? But in this case, they sat on it. December...
They said they were studying it, attorney. They said the first 2 complaints.
Di pwede yun.
There were problems with it. That's why they took their time studying it.
No. That's not an excuse.
Valid
Because
excuse.
the persons who will study it will be the Committee on Justice, no? So properly, no? So if there were problems with it, no, the the speaker should have done its job, or the Secretary General should have done its job to include it within the House of Business within 10 session days. But this was never done. No, if there were defects in it, that would be discussed at length, whether or not it is sufficient informed by the Committee on Justice.
Okay. Out of the 3 arguments that you have, that you stated in your complaint, pleading for the Supreme Court to call this 4th complaint defective, which one are you most confident in? Is it the 3 not being considered, the
verification issue, the
or
one-year
the due
prohibition?
process?
You could not really predict the action of the Supreme Court. They are highly intelligent. The justices are very learned. I could not predict. Only that the 3rd ground, I also raised it, lack of due process on the part of the Vice President. She was never informed, given notice in hearing when the complaint was filed. As filed, this 4th complaint, no, I also raised it because it is a valid, It is a valid argument because any person is entitled to be heard before a case is filed against her. If a criminal case is filed, for instance, you even have the right to respond to such complaints. How much more here, where she has been elected by more than 32 million votes, she should have been given the chance to respond. And that is why if you will read Rule 2, Section 2 of their own rules, which they did not also follow. They did not also follow. Even if you have 1/3 vote, their own rules mandate that it should have been referred to the Committee on Justice. Okay? Because that is so, my understanding is that they specifically included that in Rule 2, Section 2 so as to observe notice and hearing requirement. That is my understanding of it. No, I may be wrong, but that is my understanding because high government officials, such as the Vice President, for instance, should be given their day in court to at least preliminarily respond. And if they really have the 1/3 vote, then that would constitute now as the articles of impeachment, but you could not do away with the notice and hearing requirement because that is, there is a saying, strike, but hear me first.
Lupit.
I feel like it's a big ask of the Supreme Court at the moment because even
Natulala sila.
whether the Supreme Court has jurisdiction over this case is up in the air at the moment, and you are
No, it's
asking them.
not up in the air. I'm very sure they will entertain it. Why? Because
Well-
Baker versus Barr, a 1962 decision by the U.S. Supreme Court started all this. No, when it was before considered as a political question. Now even
Yeah.
Gutierrez case was even considered as justiciable. No, and the Corona case was even considered as justiciable.
Right,
Only that it was overtaken by events, hence the Supreme Court was not able to rule on it. My
But
only
yeah,
prayer
yeah.
is that the Supreme Court would immediately tackle the same, but as to whether or not it has jurisdiction to try it, that matter was discussed at length in Gutierrez versus House of Representatives,
yeah.
and according to the Supreme Court, it has jurisdiction,
Right.
expanded concept
Right,
of certiorari.
right. But you know, there are other legal minds that think otherwise. For instance, former Senate President Franklin Drilon, who says the Supreme Court at this point shouldn't interfere, right? Because fundamentally, this is a political exercise. We're not talking about a criminal charge here. We're not talking about a trial court. The Senate is sitting merely as a quasi-judicial body.
So ayan, maganda ho yung talakayan ni Atty. Torion. Sinuplak niya ho lahat ng mga nagsasabi na hindi, pwede yan kasi wala yung 1-year ban kasi hindi namin pinrases yung first 3 impeachment complaint. Yun nga ho yung mali doon, mga kababayan. Bakit hindi ho pinrases yung unang 3? Napaka-importante nun. Doon pa lang may malicious intent na ho sila. Meron na ho silang malisyosong gawain na hindi ho nila tinakil yung 3. Bakit? Dahil ba mahina, pinag-isipan? Hindi ho ganun, di ba? Hindi ho pwede. And every complaint, dapat to ay immediate na pinapasa sa speaker, tapos doon sa Committee on Justice. Immediate po yun. Hindi pa pwedeng mamili, itong pang-apat lang ang pipiliin namin. Hindi pa pwedeng ganun. Napaka-importante yun nun. Hindi pa pwedeng itenga. Okay, malalaman nun natin kung sino talaga mga matitigas dito. Basta at least yan, na paliwanag ni Atty. Torion yung kabubuan ng ilang mga kongresista natin. Di ba? Alam mo naman yung mga kongresista natin. Gago! Tapos ang pasasagutin nila, hindi abogado. Kaya ka mabibuisit no? Hindi totoo, di ba? Bilang pasasagutin nila yung mga hindi abogado. Pambihirang buhay reo. Anyway, yun po, yan ang ating update patungkol ho dito sa impeachment complaint na ipinasa ng Kamara na hindi dumaan sa tamang proseso. At yan naman po ay nireklamo ng mga Mindanaoan lawyers